welcome guys to our weekly cello law webinar. We're going to give it a few minutes so that people can get an opportunity to join, and then we will get started. I hope you all have had a safe weekend and a good Diwali weekend. Diwali, for those of you who don't know, is a festival of lights and very auspicious for businesses and people, and so it's kind of a combination of, I guess, our Christmas and July 4th. So in India, you'd have fireworks. Every home would do firecrackers celebrating the light, and it is also a day that businesses do a prayer to the goddess Lakshmi, who is the goddess of prosperity. And I often joke with my clients that see if you use cello law, you have Mahalakshmi, that's my full name, Mahalakshmi at your side. So let's see. Today, actually, our topics are really interesting. Every week we try to put together information that may be helpful for those who are going through the immigration process, especially given all the new restrictions that the current administration is trying to push before they leave office. So they're trying to restructure the whole immigration outline. And a good way to do that is to change it in the policy manual. And that's what we're going to highlight today. So I think we should go ahead and get started so that when people join, that they join. As we state every week, please put your questions in the Q&A, not in the chat, in the Q&A. And at the end, I will try to answer the questions. The presentation itself is very brief, and then we can focus on the Q&A. And this week, I will be moderating the Q&A myself. Mr. Challa is a little busy today, so I will do that at the end. So let's get started. So there are different ways to connect with us. First, again, I welcome those who join us every week. Thank you so much for tuning into us and joining our webinar. For those of you who are new to this, welcome. And there are different ways that we try to get the information out to people. It's Facebook, Twitter, Instagram, YouTube. We have a chock full of video recordings that kind of highlight different topics. And some of them are timely on the new changes. Some of them really relate to things that anyone can utilize and review. So, please connect with us. I love hearing from you. Please comment and share with your friends. We also have a Telegram group where we try to post useful updates on that Telegram group. You have to excuse me, I have allergies. So try to join us through that. And like I was saying, our videos, they're questions on everything from how to read a visa bulletin and Child Protection Act, how to draft a perm job description, remote work, what is permitted and what's not permitted, issues that on visa processing like Dropbox versus emergency. So please check those out, comment, and let us know if there's any topics you'd like us to cover. We'd be happy to do that. This is for you. So today we're going to talk about the things that you don't really hear about reported in the news, which is Trump push for changing immigration policies. And the focus of the new, and so they do that through, before there was something called the Adjudicator's Field Manual. So this administration started creating their own USCIS policy manual. And through that, they're changing the way decision-making can be done, how an adjudicator looks at your petition. So, for example, they recently, I think it was about 4 or 5 months ago, they expanded discretion overall that means they're giving adjudicators greater leeway into reviewing petitions. That's never good, because how do you define discretion? It's easy to define what specialty occupation is. There's regulatory guidelines, but when you expound on things that really is more about how a person factors things, it's not more objective. It becomes more of a subjective review, and that's dangerous. So here's some changes. Job portability, especially in lieu of all the adjustment filings. Typically, the I-140 has to be approved, and the adjustment of status has to be pending for 180 days in order for you to change to same or similar employment. Now, before, the definition really of same or similar wasn't specifically outlined. It didn't really have to mimic the job that was there word for word. It just has to be similar. So it was a much broader version of that. The net was much broader as to how to define that. So, of course, this administration, they started asking for supplement J's, where, at the time of filing, you have to really affirm that the job, there is a bona fide job offer. Now, this supplement J, both the employer and the employee signs, and they sign under penalty of perjury. Now, for a lot of you who were thinking about, we had a lot of folks saying, oh, once I get my EAD, I will change employers. Well, this is the constructs in which you can change. So number one, the offer of employment must have been valid at the time that you filed the adjustment and the I-140. And it has to be same and similar. So what they said that they will do now is they will look at, the job duties, the job title, education and training requirements, the required skills, and even assess the wage. Wage wasn't an issue before. If you ported, you could actually be paid less, especially in an economy like this, where, there is some concerns about job, businesses being impacted by COVID and jobs being affected. In almost all industries, there is a reduction in wages. Even in the legal field, I think most law firms, not us, but most law firms have reduced their employee wages by 10% throughout. So in all fields, there's a reduction in salaries. So this is one of the things that wouldn't have been an issue before, but they will look at, and they will look at the occupational codes assigned to the job. And they've also stated that, you can do self-employment, but you have to demonstrate that it is same or similar role, and you have to demonstrate that at the time of filing, truly the intended employment was bona fide. So, and I've been saying this from the beginning when we were talking about adjustment of status applications, that remember at the time of filing your concurrent filing, you have to have a present intent to work for the employer. So especially if you're filing a petition for a previous employment, you have to show that you've got the present intent to take that employment. So a lot of what I suggested at the time was make sure that you either have an agreement in place, you have maybe an email or something to document that you do have that present intent. When you get your EAD, it may be a good idea to join that employer. So if you're RFE'd, that's a strong sign that you've got the present intent, is if you are working for that employer, right? So the officers have to take the supporting job, supporting information and documents, but they may ask for additional information if they don't believe the evidence submitted. Now, this is important to look at in lieu of the expanded definition of discretion. In fact, the way they outline it in the policy manual is they have on one side, when they are giving guidance. So these policy manuals give adjudicators guidance on how to review. So on one side, it has all the regulatory requirements that typically you would have. On the other side, it's the discretionary factors. That was never there before. I mean, they would have some discretion, but it wouldn't, the influence of that is much greater. So now it becomes from an objective regulatory standard to more of a subjective, okay, what does this particular adjudicator think about? And there's so many factors that can impact the way you think about certain things, your background, your education. As a lawyer, I'm probably more cynical on issues, right? Because, that's my background. That's the work I've been doing. So that's what they are permitted now to bring into the review process, which I find to be very dangerous. So let's look at some of the issues that they will consider. So they state that the officer should review the entire record, give appropriate weight to the negative and positive factors relative to the privileges, rights, and responsibilities of the LPR. Once the officer has weighed each factor, he should consider all the factors cumulatively to determine whether the positive factors outweigh the negative ones. The officer determines that if the officer determines that the positive factors outweigh the negative factors, the officer may find the applicant warrants favorable exercise of discretion. Now, this is at a time where we're seeing RFEs at an all-time high. We're seeing denial rates up. So clearly, there is an anti-immigration bent to the whole review process as it is, giving those individuals more power to use subjective standards is a way in which you can, they may try to be, no, it's not that they may try, they're trying to increase the denial rate. Now, I'm very happy to report that we had this ridiculous L1A RFE, and it was asking for all sorts of absurd things that they shouldn't have asked for. So I filed the RFE on Friday with a very strong, respectful, but strong response, telling the adjudicators that what they were doing was, because they said that they didn't have to, one of the things that they said is they didn't have to really look at federal court cases. Oh no, this was for another RFE. They didn't have to look at federal court cases and assess, use that as precedent for their adjudications. And I said, well, you may not think that, but the Supreme Court thinks otherwise. And the Administrative Procedure Act directs you to think otherwise. So yes, you do. So this is what, in the context of this background, where we're having adjudicators say, I don't have to pay attention to federal court decisions, and I don't have to, I can question, issues that you submitted 3 times already because we don't give discretion to previously approved petitions. It is a landscape where it is very caustic to give somebody unbridled, if you will, power. So some of the positive and negative requirements is the eligibility requirements. So do they meet all the eligibility requirements? Not meeting the eligibility requirements may be considered part of the discretionary analysis. That's absurd, because if they don't meet the eligibility requirements, they can deny it anyway. Family and community ties to the United States and the closeness of the underlying relationship. Hardship to the applicants if the adjustment of application is denied. Length of lawful residence in the United States and the conduct during that time. So if the person is single and they're dedicated to their job, that's going to be a negative factor now. And so they don't have a lot of community ties. Compliance with the immigration laws, that would be a factor anyway. Violations of immigration laws and conditions of any immigration status held could be deemed a negative factor. Now, there is a section called 240K within the regulations, 245K, and that's within the adjustment regulations, where if you've worked without authorization, as long as it's less than 180 days, you can still adjust status in the United States. So is this a way that they're able to deny something because it's less than 180 days? It can be used as a negative factor now, whereas before it would not have been able to be used as a negative factor. False testimony, unexecuted deportation, that would have happened anyway. Then property investment or business ties to the United States, employment history, including type, length, and stability of employment, education and specialized skills from an educational institution in the United States relevant to the prospective employment, the history of unemployment or underemployment, unauthorized employment in the United States, employment income from illegal activity. Even the things that are deemed to be, on one of the positive factors, property and investment or business ties. What if you are fairly new to the United States and you haven't bought a home yet? And you haven't bought a home yet because you're not sure if your immigration status is going to continue. That could be used now as a factor. And employment history, including length and stability of employment. At a time right now where it is, unemployment is at a record high and it's, people are struggling with all sorts of issues. So it's that common theme of hire America, buy America, and the idea that the USCIS currently has that foreign workers are taking US jobs. So this is a way in which they can try to deny the application. Community standing and moral character, respect for law and order, and good moral character demonstrated by a lack of a criminal record and evidence of good standing in the community. Compliance with tax laws, honorable service, demonstration of reformed or rehabilitated criminal conduct where applicable. Community service beyond any imposed by the courts. That is a criteria of the naturalization application. It's never been a criteria of the adjustment application. Moral depravity or criminal tendencies in the US and abroad, reflected by a single serious crime of an active or long criminal record, including the nature, seriousness of recent occurrence of criminal violations. Now, if it's a felony or two misdemeanors, that is an admissibility issue, and that has always been, you would have always had a problem adjusting due to that anyway. So it would seem to me that would not be one of the, they're trying to lower that bar. And so they're trying to do this not only without notice and comment, but as an affront to what has already been imposed by Congress. Public safety or national security concerns, failure to meet tax obligations, failure to pay child support, failure to comply with applicable civil courts. What if you had a DUI? Right now, a single DUI, a single occurrence of that is not enough to bar adjusting status in the United States. There have been times we have consulted with folks where the perceived, the neighbors perceived that there was a domestic occurrence because the couple was talking loud. They couldn't understand what they were talking about because it was in a different language. And the police were called on a domestic violence issue. There is no crime associated with that, but would that be something to say that would impact your good moral character? I don't know. It would depend on the person that's reviewing the application. Oops. So you have to add up all those factors, and if the positive factors outweigh the negative factors, then the adjustment is approved. Unbelievable. Naturalization tests. They want to increase the test bank from 100 to 128, double the number of questions, and increase the passing rate. So this applies to all applicants after December 1st, 2020. So if you are thinking of applying for naturalization, this is a good time to get started. Not that this would, if you're going to pass 100, you can pass 128 questions, but it's still really critical that if you're able to do it early, so you don't have to overcome these great burdens, it will be a good thing. Just remember these additional issues that are in queue: the DOL wage rule, strengthening the H-1B, which is effective December 7th. Legal challenges are there. Nothing has happened yet. There has not been any stay. Stay tuned for any new information on that. The proposed way in which they're going to choose the H-1B lottery based on wage, which is, ridiculous. Limiting F1 students to fixed duration of status, and limiting EADs for individuals with final removal orders through DACA. So, and you ain't seen nothing yet. They're going to have many more new types of regulation. They're not really regulations because they're not going through notice and comment. They're just doing it through the USCIS policy manual. So they made it, if you remember a couple of weeks ago, I talked about how it used to be really easy to get updates when a change was made, because you could get it through, the portal that allows for notice and comment through the APA. Now they made it much more difficult to do that. So we are still getting those updates, and I get updates like all the time. Sometimes it's not newsworthy, but it is constant. And they have signaled that they are going to try to bulldoze through a number of things before the end of the year. They provided clarification on Child Protection Act. Recently, the district court found that the acting Secretary Wolf was not lawfully appointed when he suspended DACA. And does that impact other policy changes? The Department of State announced the resumption of routine visa services on a post-by-post basis. We'll have to see, how that plays out, because COVID cases are increasing. And then remember, the presidential proclamations remain until the end of December, at which time they can be extended by the administration. So I'm sure that we will have more things to talk about, thanks to all the changes that the USCIS is making. Some of these are really concerning, especially the adjudications. If you look at the timing, they wanted people to file because they need the money, and they only implemented these changes afterwards, so that they could deny them. It is beyond sketchy. Let us know what you want to see next week. Please, email us at info@cellolaw.com. Remember, if you haven't joined our Cello Chats forum, please do that and connect with us that way. I'm sure Kara, through chat, will send out all the links as she does in previous, seminars, and connect with us on social media, YouTube. We would love to hear from you. And you can view the recordings, like I said, of our previous webinars where we talk about a lot of these critical issues. So please do that and share with your friends. If you're enjoying what we're doing, that's the one thing you could do. I get these lovely emails from you about how you find the information to be helpful. So if you do, that would be wonderful if you would share it with your friend group. And like I said, if there are any questions you have, email us at info@cellolaw.com. So right now, I'm going to start with answering some of the questions that you may have. The first question, anonymous attendee: I have my GC perm and filed and approved in 2008. My I-140 was also approved in 2008 by employer A. 6 months later, the company was broken down and sold off to multiple companies, so I left the company. Based on the above, if my I-140 was not approved for this case, can I still use my 2008 priority date for a perm application with a new employer, or do I lose it? So the question is about the portability of a priority date when the I-140 was not approved. I think in 2008, they were taking about 10 months or so to approve I-140s, and there was no premium processing for I-140s. So it is more likely than not that your I-140 was not approved. And if you're not sure, why don't you try to find out? If you had a receipt number, you can use the receipt number to find out whether it was approved. Because if it was approved, then you would be able to port the priority date. But the I-140 must be approved in order for the priority date to vest with you. So good luck. Find out if you can find out about whether it was approved, and I hope it was, so you can utilize it, because our 2008 date is really critical. So Molly Eisworth: I was curious about the H-4 requirements for work. I was reading that a person with an H-4 visa is not eligible to work unless getting the EAD paperwork. Is that correct? Yes. So there are work authorized status, where the status itself gives you authorization to work, like an H-1B, like an L-1. The H-4 on its own is not an eligible work authorized status, just like an F-1 student on its own is not an eligible work authorized status. So the work authorization that you receive pursuant to that status is based on receiving, not just filing, on receiving an employment authorization document pursuant to filing an I-765. So unless you get the actual card, now you don't have authorization to work. If you're getting an extension, there are certain instances where just the mere filing of the EAD, very limited, would allow you to continue working. But the H-4 in and of itself does not give you employment authorized status. I hope that helps. Shri: I got my EB green card 2 weeks ago. I got a note from you that I should at least stay with my sponsored employer for 6 months before changing jobs. Can I change the job now? Would it impact my naturalization? Well, with the current, I think if you've already gotten your, and when I said that you need to stay with your sponsored employer for 6 months changing job, you want to make sure that that you can demonstrate that you didn't just, that you did have the intent to continue employment. The 6-month rule was probably pursuant to the portability issue. So if your I-140 is approved, your adjustment has to be pending for 180 days, 6 months, i.e. before changing jobs. But you can change a job now. Would it impact your naturalization? It depends on who's president at that time. You've got 5 years on permanent residence before you can file, so we'd have to see it's not even this administration, it would be the next administration, how they change the naturalization rules. If you want to be safe, I would stay at your job, at least for a little while. There is no time frame that is necessary, and currently there's no requirement, but maybe staying for a few months so you can show that you did, your process was bona fide. Spouse's passport is expiring on December 15th. I filed for a passport renewal. Not sure when I will receive the new passport with the new service provider. If I apply for an H4 extension with the current passport, December 15th, no, they state very clearly your passport has to be valid for 6 months beyond the date that you are asking for the validity of your extension. So what you can do is you can file the extension and then submit a copy of that you have asked for a passport, a renewal of your passport, and hope that they'll send you an RFE, and by that time you should have your new passport and you can send that copy in. Are there new updates when premium process will be applied to EB2 NIW? I believe that is already underway, but if you have not joined our Telegram group, we will post, an update on that to let you know that it is. But I believe I remember seeing that because I was surprised they would roll it out that quickly. But I believe it is, but we will confirm and post it on that group. Ma'am, are we seeing any receipts coming through for the downgrades? We're not seeing the receipts, but what we've done is we're looking through the bank. So Kara says that there's no update on the implementation, but she sent it out through chat, so that's great. You all have the information. But so on the back of the cashed receipt, we do have a number. So that is your receipt number. So we're sending that to our clients so that they know at least that their adjustment was received. So you can ask your attorney to do the same, if it's their check or if it was your check that was used to file it, you can check your bank account to see if the checks were cashed. Are the downgrades going to be affected by these policy changes? That's a good question. It depends on who's going to be president. If President Biden comes in, I hope, we're trying to make sure that they understand that it's not just the things that you hear in the news, but the things related to the USCIS policy manual that they will have to revamp when they come into office. So hopefully you will not. Hopefully there will be a new administration and they will use the adjudicators field manual until they can revamp it and institute their own USCIS pro-immigration policy manual. Next question. My I-140 was approved in 2011. Later, I was transferred to the same company's subsidiary. Recently filed adjustment of status. If my company lays me off, then does it impact my adjustment application that was filed last month? Yes, it does. It may go through. Well, there's two things. Number one, yes, you are AOS, but you're an adjustee, but what's your underlying status as well? Because remember, for portability to kick in, the I-140's got to be approved and the adjustment has to be pending for 180 days. If you think that the company will rehire you, that would be, a way in which you could continue working, or you may have to just transfer to a new company and have to refile all over again, and hope that the priority date for whatever classification you're seeking is current. I'm sorry to hear that. That's really tough. Good luck to you. Any idea when H4 EAD premium processing will start? I think that's all part of that same new premium processing initiative. And Kara just posted that on chat that it's been authorized, but it hasn't been instituted yet. Ms. Challa, since the H1 wage levels have increased, can my extension be filed at a lower wage level than my initial H1 petition? That's what a lot of people are doing. I just suggest that you don't do that premium. I would do that regular processing and hope that it gets adjudicated during a time where there's a new administration. Do I need to be on an H1B, or can I be on the I-485 pending status? I always tell people to stay on their H1B, because that way you have a safety net if something should happen to your I-485. Because if you don't have an underlying status, if your I-485 is denied, then you're out of status. You can't then change to any status in the US. You'd have to leave. But if you are on an H1B or L, if your I-485 is denied, you can, there's lots of things you can do. You can appeal it without going out, worrying about unlawful presence in the United States. You can refile because you're in an authorized status. If you're not, you won't have any of those opportunities. I am planning to file my H1B extension by next month. My previous H1B extension was wage level 4. With new wage levels changing, I'm falling into wage level 2 for the same SOC code. Client has changed my job title in the month of May. My job responsibilities are the same. My employer said an amendment was not required at the time for the title change since the responsibilities are the same. Since we have a new title change, now my employer is saying that we can use a different SOC code, but the wage level is 3. Can I apply my extension using this code and wage level? If so, do I need to file an amendment plus extension or just an extension? If you're going with a new SOC code, I would do an amend and extend. That's not an additional cost to your employer, but I think that is a more prudent way to do it. And like I said, I would just suggest that you file regular, don't file premium. I'm telling everyone that's filing extensions or H1B change of petitions now to do that. Next question. Ms. Chella, thank you for your guidance and time always. I need to renew my H1B next year, and I'm an employee of my green card sponsor. There's no placement, a statute agency in the middle. Good. The question I have is regards to my salary. How do I know if my employer and I are meeting the salary requirements for a successful H1B renewal? If it's next year, Jay, I wouldn't worry about that right now because one, there are a lot of legal challenges, and I think they will be successful in those legal challenges to the new wage levels. Number two, when we have a new president, that is one of the things that, in fact, big tech donated a lot of money to the Biden campaign. And we know that even though the Biden campaign did not comment, big tech stated that they told them that they wanted to roll back all the H-1B restrictions imposed by this new by the Trump administration. So that may not even impact you next year. Rajiv, hi, Lakshmi Gautam. My priority date is June 27th, 2007. My new employer has an approved perm now and is applying for EB3 in November. Do you recommend also applying for EB2 I-140 now instead of upgrade later? Doing an interfiling dates more favorable? Absolutely. If you are filing a petition now, and this is how you could do this. You can, if you're doing it premium, you can file the EB2 and EB3 both at the same time. One would have the labor cert, the other would not. But because you're filing them together, you're allowed to file them through premium processing. You just have to meet the eligibility for both. So just make sure you meet the eligibility for both. But that is something that I would file premium. If you're concerned about the dates, then just file the regular processing with one filed concurrently with the adjustment of status. But if you are not concerned about the dates, then go ahead and file them premium and then file the adjustment of status. And that way you have two approved, and you could use either one. Good luck to you. Ma'am, will the LCA be certified in DOL in case we use private surveys instead of OES wages? Yes. And next week, I'm going to cover, one of the things I will cover is what to look for if you are using a private survey. What are some of the surveys that AILA members have recommended? But what are the things that you need to look for? So make sure to check out next week's webinar on private surveys. Is there a limit how long you can be employed on a GC EAD if the H1 is not maintained? Not really, but remember, in order for you to change employment, the I-140 has got to be approved and the 485 has got to be pending for 180 days. As I told the person that asked earlier, if you are terminated, then that may impact your ability to seek new employment, because you can't change employers. You would have, if you're not employed for the full 180 days, then you're not eligible to port. And if your H-1B is not maintained, then you're going to have status implications. So my suggestion to everyone is maintain your H-1B. If you get terminated, then you can change employers. And if it's less than 180 days, you can file for a new green card. So my husband's, once I receive the EAD-AP, I believe I can travel and come back on an AP without going through H-1B stamping. Once I come back, till I file my H-1B extension, I would be on the EAD and not H-1B. Can I extend my H-1B when I am due later as I normally to come back on an H-1B status? Yes, you can, and this is how you would do that. The rule is you can work on the H-1B or EAD and enter on an AP. What you cannot do is use that EAD to work for an employer other than your H-1B employer. So when you come back and file for your extension, you would submit your pay stub showing that you were paid by this employer. Submit a copy of your EAD and AP that you entered on the AP, and you're working on the EAD until you filed the extension. So you were working with authorization and you were working for your same employer. That's the evidence you would submit. I hope that helps. Good luck. If I lose my job on an H-1B, how long can I stay in the US? Applied AOS last month, waiting for GC, EAD, and AP. Gosh, I'm so sorry again. It's the same question. So the H-1B, typically to maintain the H-1B status, you have 60 days grace period in which you can find a new job. I would suggest you try to do that, because if you have, because you applied for adjustment of status last month, the only way you can port is if your I-140 is approved and your adjustment of status has been pending for 180 days. It hasn't been pending for 180 days. So you will most likely have to file a new green card application. So you want to make sure that you find a new employer to sponsor you on the H-1B. Then, initiate that process again. And that way, if there is a question asked, an RFE asked, then you would have at least started your new process. My husband's H-1B extension is approved, but my H-4 extension is pending. My EAD card is expiring. Do I get automatic extensions and can I continue working? No, you do not. And you have to stop working until your EAD is in your hand. So there's a lawsuit against, the delays in H-4 EADs. They are doing this purposely. It is ridiculous the time frame it's taking, citing to biometrics and other things. So let's hope that that court case can get them to push it. But H-4 EADs is not one of the classifications that get that are permitted the 180-day rule for other EAD applications. The 6 months AOS pending you mentioned earlier to stay with the current employer, does a 6-month period start from the date of the AOS submission to the USCIS or from the EAD? Good question. It's from the date of the AOS application to the USCIS, not the date from when the EAD approval rate is. EADs, as I've said in the past, are just a benefit that you get when you apply for adjustment of status. The application is the adjustment of status. So that's what really governs. And even though I asked you guys not to ask me questions on here, but this is a nice comment. Thank you, Chella. You guys are doing a great service for the community. If you can send us an email, what we would like to do for next week's is at least let other people know. Share it with your friends. That would be something. If you think what I'm doing for you is helpful, that would be something you could do for me, and I would be really grateful if you were able to do that. Today I didn't want to cancel the webinar, and as you can see, I'm probably not in a great state. My daughter was not feeling well, and so my husband had to go to St. Louis to pick her up and bring her back home. And so I have been very upset, but I said I knew that you all were counting on me, and I didn't want to let you down. So I wanted to make sure that we still had the webinar for you today. There's another question. Once I receive the EAD, I believe I can travel and come back without. Okay, this is a question I think we already answered on the EAD AP. So the key thing, folks, to remember about EAD AP and its relationship to H-1B is the rule is you can't work for an employer other than your H-1B employer, otherwise you're in violation of your H-1B status. So if you remember that one rule, everything else is okay on how you go about doing this. I think we have another question. If the H-1B is maintained and only AP is used during entry in the US, will the H-1B be valid without stamp and work on the H? Absolutely. The question is, can I enter on an AP and then work on my H-1B? Yes, you can enter on the AP and work on your H-1B, and that is fine. You can, if you're entering on the AP and your H-1B had already expired, and you want to file for the H-1B extension once you're in the US, it would not really be an H-1B extension per se. It would be because your status is expired, so you're not extending. But what they could do is apply as an H-1B not subject to the cap, show all that you've maintained status, you've used your EAD to work for your employer by providing pay stubs, and get an approval that way. So it wouldn't be filed as a extension, it would be filed as an H-1B new, not subject to the cap. Ma'am, I have a question. My wife's STEM OPT expires May 2021. I want to file F1 to H4 and H4 EAD now. I want to apply H1 for my wife. Can I have, yes, what you can do is go ahead and you would just withdraw one of them. So there's something called the last action rule. So whatever the last action is on your application, you would just withdraw that. Now, if you file for your wife's H4 EAD, it may be, still pending, if current processing times are any indication, by the time the H-1B cap season is headed. So if they allow for premium processing during H-1B cap, you can file the H-1B premium to make sure it's been selected, and then withdraw the EAD. Or what you can do is you can file the H-1B for consular processing, right? File for the H-4 EAD. If it's approved, you can file an amended petition amending the H-4 to an H-1B with an I-94 card number. That's what I would do. So you file your H-4, change of status to F1 to H-4 now. And for H-1B season, you file it as an H-1B cap case for consular processing. And if it's selected and approved, you file an amended petition so you can get your I-94 card without having to leave the country. Jay, hope your daughter feels better soon. Thank you. Thank you. Prayers. Will the GC subjectivity rules you presented earlier be possibly, they will definitely get overturned by Biden. That's something we don't have to worry about. And they're also going to be challenged in court. I mean, they've changed the whole way in which the review process is. You can't do that through without going through a certain process, number one. Number two, Congress has spoken on that. When Congress has spoken on a particular issue, the agency is not allowed to change that. Only Congress can change that. So they don't have the authority. And the Biden administration will revoke all these ridiculous restrictions. How do I switch from H-1B to EAD with my current employer while staying in the country? I received an EAD from my spouse. Well, you don't really switch. So where does that come into play? Your employer probably I-9'd you and used your H-1B information for the I-9. If you want to then use an EAD instead, they would probably have to update their I-9 records to reflect that your work authorized status is EAD. But there's no changing of that status per se. You kind of have flexibility of both. But once you work for an EAD for an employer other than your H-1B employer, then your H-1B status is no longer valid. If you want to use the H-1 again, you would have to file for a new H-1, not subject to the cap. After you get the I-485 receipt, if the H-1B extension has issues or RFEs, can I continue on the I-485 before you get an EAD? The 485 allows you to maintain status in the USA. The adjustment of status, or I-485, does not per se give you the authorization to work. It's the employment authorization card that gives you the authorization to work. Can I change employer after getting a GC EAD? The new employer has to pay the equivalent or greater the perm wage, and while the green card is still pending. That's the same thing I answered previously. The portability of the green card only is only applicable if you your I-140 is approved and your adjustment of status has been pending for 180 days. So if you change employers before that time, then your adjustment will be denied and you will have to go through the process all over again. So that's something to really make sure that you pay attention to. Thank you all again this week for joining. I think there's one more question and we have time for one more question. Let's see what the question is. Ms. Cello, when an OPT EAD, when on OPT EAD, I got my GC EAD, do I need to inform the USCIS explicitly? No. You would just use the green card EAD. So there's nothing that you have to do to inform everyone. Guggen says, Ms. Chawla, I appreciate all your help for the community. We're counting on you for your continued support. That you will get. And like I said, I wanted to thank you all. Okay, there's two more questions. Sorry for one last question. If you could answer, follow up on the 485 receipt. So that does not mean I can stay in the US, but not work until I get an EAD. Yes, you can stay in the US. So the two parallel things is your status can be that of an adjustee, but you cannot work without your EAD. Now, if you're the primary applicant, remember the portability rule, and you have to have the adjustment pending for 180 days before you change employment. If you are a dependent, then that doesn't apply to you. So, you can be flexible in, you don't have to worry about your status because if you've got an independent H-1B status and your spouse is the primary, then you don't have to worry about the portability rule, and you would be in valid status as an adjustee, but you could not work until you get your EAD. It seems like, as I answer, somebody said, thank you, wish your kids get well soon. Well, she's not really a kid. She is in law school in St. Louis. She wants to practice healthcare law because she thinks it's ridiculous what we pay in this country for healthcare. So my previous employer is not providing a copy of the perm approval. How do I get a certified perm is it from the DOL or can I request it? That's weird because, oh, your previous employer. Well, you would have had to have signed it. At some point you would have had to, that would only be relevant. They would have had to submit it with the I-140. You can do a FOIA request with the USCIS and ask pursuant to the Freedom of Information Act, and then they'll be able to provide that for you. So it's a FOIA, FOIA request, Freedom of Information Act. Pursuant to that, I would file with the USCIS because your I-140 petition will contain your Department of Labor perm. My husband is approved, H-1B is approved yesterday, but H-4 and EAD remains and change not approved. My wife, EAD expired on September 13th, applied for premium, but they did not encash the check due. H-4 EADs take more time. Yes, because of biometrics and the H-4 EAD premium processing provisions, as I think Kara posted twice, was authorized by the Emergency Stopgap USCIS Stabilization Act, but USCIS will determine when it will proceed with expansion. So they haven't implemented it yet. It's been passed, but it hasn't been implemented. So that'll be all for our questions today. Thank you again. Like I said, if you've enjoyed this section, please share it with your friends, send us a note, join us on social media. Our Telegram group and social media links are posted. Next week will be a really important session as I talk about not only the new rules, but anything that has to do with using alternative wage surveys. And so stay tuned for that because that's going to be critical for everyone. Thank you again, and I'll see you next week.